Slavery, as an institution, is as old as humanity itself. Civilizations from Egypt to China, Greece to Rome, and even indigenous African societies practiced slavery in various forms. Yet the form slavery took in the 13 British American colonies during the mid-17th century was unique. Here, the condition of being a slave in colonial America had only an extra-legal underpinning, and yet it became inheritable and permanent due to the corruption of colonial America's 13 British American governments. Further, although colonial America's slave codes and Negro laws violated English law, they were enforced as being lawful, codified colonial laws by corrupt colonial British government officials within the 13 British American colonies. Nearing the end of the 17th century, Parliament's English Bill of Rights, 1689, which was ex post facto legislation, retroactively nullified colonial America's slave codes and Negro laws. This act of Parliament incorporated into law the growing conviction that although some Englishmen may inherit privileges, all people enjoy fundamental rights, in particular, liberty, which could not be taken away, abrogated, lessened, or interfered with, even by England's monarch, who also became subject to English law. Further, the British imperial government legislatively abolished colonial America's slave codes and Negro laws for all purposes whatsoever, by way of the American Colonies Act, 1766, 10 years before the Declaration of Independence occurred in July 1776. Then 6 years later, England's highest tribunal, its Court of the King's Bench, declared in the 1772 habeas corpus case of James Somerset versus Charles Stuart that slavery was unconstitutional throughout the kingdom, meaning slavery was not listed, not expressly provided for, and not authorized by a written enabling act of Parliament. The Virginians, who to a man owed their financial stability to the odious practice of hereditary slavery, became the de facto leaders of America's rebellion, and their pro-slavery views and interests impacted the resulting war with Britain. However, addressing the free Negro population and a robust abolitionist movement in northern colonies that were advocating liberation for all colonial American slaves in accordance to the historic Somerset decision were problematic issues for them. Then one might ask, how did slavery emerge in the United States? The coming together of America's founding fathers created an uneasy alliance of divergent ideologues, and it was as historian Edmund S. Morgan, in his book, American Freedom, The Ordeal of Colonial Virginia, observed, "The men who came together to found the independent United States, dedicated to freedom and equality, either held slaves or were willing to join hands with those who did. None of them felt entirely comfortable about the fact, but neither did they feel responsible for it. Most of them had inherited both their slaves and their attachment to freedom from an earlier generation, and they knew the two were not unconnected. And after the American Revolution ended, America's first Congress feared disunification over the slavery question, and as many of the founding fathers claimed ownership of black colonials, the 500,000 black Englishmen were denied fundamental due process of law, enslaved and exploited here in the United States. Had the United States adhered to English law and controlling precedents, such as the historic Somerset decision that slavery was not allowed and approved by the law of the kingdom in 1772, as America's first Congress formally adopted Anglo-Saxon jurisprudence and English law in 1776, which the 13 state legislatures then adopted, these 500,000 black Englishmen, who became the bedrock of America's slave-based economy, would have been set at liberty under the Treaty of Paris of 1783, and black slavery in America would not have been institutionalized in the U.S. Constitution. Slavery in the 13 American colonies was the product of a criminal enterprise that compromised the rule of law. English law made the first 19 Africans that arrived in the colony of Virginia in 1619 18, indentured servants, not slaves. This legal status conferred them freedom after their term of indenture. Under English law, hereditary slavery and the institution of slavery were not recognized on British soil. Their colonial charters, granted by the Crown, bound each colonial assembly to pass laws with the imperial government's approval only if they were consistent with English law. Their children born within the British American colonies had birthright English subjecthood and were legally free people by English law. Colonial American slavery was uniquely harrowing because it was built on an ideology of racial superiority in violation of the rule of English law. This colonial British American slave system materialized through the enactment of extra-legal slave laws within the 13 British American colonies, laws that cruelly defined black lives through 4 principal legal categories: the term of servitude, marriage and family, police and disciplinary powers, and property and civil rights. Though distinct, these pillars of oppression sprang from a single source: the colony of Virginia's 1662 hereditary slave law of partus sequitur ventrum, the first colonial American statute codifying the perpetual bondage of black people. Colonial elites manipulated and bribed colonial governmental officials to adopt cultural and religious narratives that stripped black colonials of their fundamental legal rights under the colonial charters and the English Bill of Rights, 1689. Racism was used, which long simmered in the background to justify their enslavement at birth. Blackness itself was criminalized and whiteness exalted by the pretended enactment of colonial slave codes and Negro Laws. Moreover, within 2 generations, hereditary slavery became a fully entrenched system throughout the 13 British American colonies, engineered to secure economic power for a few while condemning millions to generational, inherited exploitation and suffering. This was not an accident of history. It was a deliberate construct, a machine of oppression designed to sustain itself indefinitely. Let's be clear, black slavery in the British colonies was neither natural nor inevitable. It was the product of calculated human choices, rooted in criminality and enabled by the utter collapse of the 13 colonial British governments, as they sanctioned and profited from the brutal dehumanization of an entire race of their own people. The extra-legal colonial law redefined people of African descent as property and placed them below the rule of English law. This misanthrope system was built brick by brick. Colonial slavery was not founded on legitimate laws, but on sheer lawlessness, fueled by the unchecked corruption of the 13 British American governments that institutionalized racial subjugation. But what if America had taken a different course? What if, after declaring independence, the founding generation rejected the enslavement of their black countrymen and upheld both the English rule of law and the Declaration of Independence's defining principle, that all men are created equal and endowed with inalienable rights, including black colonists? What if they had recognized and adhered to the landmark Somerset versus Stewart 1772 ruling, in which England's highest court affirmed that slavery had no legal basis in English law and upheld parliamentary sovereignty over colonial legislation? Instead, America's first Congress, despite Thomas Jefferson's dire warnings, chose to formally adopt English law in 1776, binding the new nation to Anglo-Saxon jurisprudence and legal precedent. Yet, in blatant contradiction, they denied due process to 500,000 black Englishmen, enslaving British subjects and their descendants, who, under the Treaty of Paris, 1783, were legally entitled to liberty. This hypocrisy not only entrenched slavery, but also betrayed the very principles the Revolution claimed to uphold. The English Civil Wars, 1642-1651, and then the Glorious Revolution, 1688-1689, were struggles to establish a strong imperial government which were realized in Parliament's English Bill of Rights, 1689, which enshrined key principles such as that the monarch could not rule without Parliament's consent, the king could not suspend laws or levy taxes without parliamentary approval, and all citizens were guaranteed certain rights, including protections from cruel punishments and arbitrary imprisonment. These British imperial ideals established that no one in the kingdom would ever be above or below the rule of English law, and that British law was now king. The English Bill of Rights was problematic for colonial American slavery, as English common law, now prohibiting slavery at birth, became codified habeas corpus protections throughout the kingdom by way of Parliament's English Bill of Rights in 1689. This was soon reflected by legal decisions such as England's highest tribunal, the Court of the King's Bench, in the case of Smith versus Brown and Cooper in 1702, declared, "As soon as a Negro comes to England, he is free. One may be a villain in England, but not a slave." Anglo-Saxon jurisprudence and English law states, "A void act does not become good or valid with the passage of time." In Rooke's case in 1598, the English court underscored this legal principle, declaring void legislative acts carried no legal force, no change in legal condition, and required restoration to the status quo ante. This legal principle directs us to concede all colonial slave codes enacted during the 17th and 18th centuries in colonial British America without imperial permission were void ab initio from the beginning, and remained void as the assemblies overreached their lawful authority by violating colonial charters. During colonial times, colonial assemblies served as the lower houses of colonial legislatures. And without formal approval from the British imperial government, the upper house of the colonial legislature, these assemblies could not unilaterally pass a colonial slave code or any law. Further, as colonial assemblies did not have permission from the imperial government, the practice of colonial slavery was only a de facto condition, not legally authorized. Within this framework, children born to black colonial mothers were enslaved at birth, creating an extra-legal system of generational bondage that deprived colonial-born black individuals of their liberty and legal protections. The hereditary slave codes of partus sequitur ventrum, that the condition of the child follows that of the mother, directly conflicted with the established English legal principle of partus sequitur patrum. The condition of the child follows that of the father, and they also violated the English Bill of Rights. Lacking formal approval or sanction from the British imperial government, these colonial slave codes were void ab initio and had no legitimacy under English law. Thus, under English law, black individuals born in the 13 British American colonies were legally free British colonials when the Founding Fathers declared independence in July 1776. This claim is advanced because colonial slave codes and Negro laws never had any legitimacy under English law and were legislatively nullified by Parliament in 1766. And in 1772, England's High Court in the Somerset case declared slavery was not authorized under English law. Consequently, as the colonial slave codes were void ab initio and abolished by Parliament's American Colonies Act, 1766, 10 years before the Declaration of Independence, these black individuals living in the 13 British American colonies held unrestricted English subjecthood when America's founding fathers declared independence. In 1766, with tensions high after the French and Indian War, Parliament exercised its supreme legislative authority over the American colonies, passing the American Colonies Act, 1766, commonly known as the Declaratory Act. This act exercised parliamentary sovereignty, and it legislatively abolished all colonial American laws in all cases whatsoever, which denied or questioned Parliament's supreme lawmaking power over the American colonies. Further, it nullified all colonial laws that conflicted with Parliament's authority, which included colonial America's slave codes and Negro laws, because they specially challenged Parliament's English Bill of Rights, 1689. America's slave ownership claim is baseless, as the 1772 Somerset decision, 3 years before America's Revolutionary War began, had judicially determined slavery was not allowed and approved by the law of the kingdom. In taking time to look at America's Declaration of Independence, it finds the founders denouncing England's King George III for abolishing our most valuable laws, which fundamentally altered colonial governments. Books like these behind me refute America's claim that the 500,000 black colonials living in the 13 colonies were lawfully excluded from the Declaration and were chattel under English law when America's Revolution began in 1775. An Afrofuturistic narrative for our 22nd century historian Stanley M. Elkins noted in Slavery, a problem in American institutional and intellectual life. A study of colonial slavery as a distinct academic discipline was underdeveloped when the United States emerged in 1776. He emphasized that English law was the discipline best suited to impose an objective standard of scholarship on colonial slavery. He cited England's rule of law as a fairly good and dependable tradition. Elkin's observation that colonial slavery was an underdeveloped academic discipline in 1776 directed me to England's Magna Carta of 1215 and the first principal methodology of stripping away all preconceived notions, and to begin with the foundational inquiry. What act of the British imperial government conferred unto the 13 British American colonies the legislative power and authority to legalize colonial American slavery? This threshold inquiry caused a rigorous examination of the legal foundation of colonial American governance, beginning with the Royal Colonial Charters and legislative acts of the British imperial government and Parliament that defined and regulated the legislative authority of colonial American legislatures. This research revealed that colonial slavery was an extra-legal institution, and that Parliament's English Bill of Rights, 1689, functioning as ex post facto legislation, effectively nullified colonial America's slave codes and Negro Laws. Furthermore, if there was any doubt, the American Colonies Act of 1766 legislatively abolished these same laws, as they directly challenged Parliament's supreme legislative authority. Reaffirming Parliament's control over colonial slavery, England's Court of the King's Bench issued the landmark Somerset decision, 1772, unequivocally ruling that slavery was not allowed and approved by the law of the kingdom. This ruling reaffirmed that the British imperial government, not colonial legislatures, held the supreme and final lawmaking authority in the kingdom, including the institution of colonial slavery in the American colonies. The Declaration of Independence, July 1776, further substantiates this point, as the Founding Fathers admits that England's King George III abolished our most valuable laws, fundamentally altering our form of government. Moreover, America's first Congress and all 13 state legislatures formally adopted Anglo-Saxon jurisprudence and English law, despite Thomas Jefferson's explicit warnings against doing so. Jefferson, fearing that English jurisprudence would undermine slavery in America, sought a complete legal break from Britain. Yet Congress instead chose to adopt Anglo-Saxon legal traditions, effectively reaffirming the Somerset precedent, which had ruled slavery had no lawful standing under English law. These historical facts refutes the accepted narrative that America's founders lawfully owned black colonials in 1776, and that slavery in the American colonies was a lawful practice. Afrofuturism can be an effective tool to stimulate scholarly research regarding colonial American slavery, Parliament's English Bill of Rights, 1689, and the American Colonies Act, 1766. Afrofuturism can challenge dominant narratives, allowing us to confront historical injustices while envisioning alternative realities where Black people flourish in technologically advanced and socially equitable societies. This powerful intellectual, artistic, and cultural movement merges historical reclamation with speculative politics, science fiction, and technological innovation to explore Black identity, agency, and future possibilities. Such a tool is essential, as history cannot be undone. The 500,000 Black Englishmen who were unlawfully enslaved and exploited became the economic backbone of America's slave-driven economy. Their liberation was denied in the past, but the story of their victimization must not be denied to future generations. Afrofuturism enables us to reclaim and reinterpret American history, an essential process in understanding who we are as a nation. By reimagining Black history beyond systemic oppression, it acknowledges a fundamental truth: the enslavement of these 500,000 Black Englishmen after the American Revolution violated the very English legal traditions that the United States formally adopted in 1776. Their subjugation was not only a betrayal of due process, but also a violation of international norms. Historical records confirm that even Thomas Jefferson, a slaveholder founding father and the principal author of the Declaration of Independence, grappled with the moral and social consequences of slavery in his 1785 work notes on the state of Virginia. He recognized slavery as a brutal, lawless institution that degraded both the enslaved and the enslavers, corroding America's democratic ideals and the rule of law. Jefferson warned that slavery was more than an economic system. It was a moral poison that threatened the very identity of the new republic, undermining its aspirations as a just and lawful society. Jefferson's assertion that slavery constituted despotism, historically associated with totalitarian states and dictatorial rule, was a provocative and striking view. He knew of slavery's corrupt origin and Parliament's abolition of colonial slave codes by way of the American Colonies Act of 1766, as he listed the abolition of slave laws as a grievance in the Declaration of Independence in July 1776. Jefferson's view provides a lens to reconsider America's narrative that the Declaration excluded Black colonials and the emergence of white supremacy and exceptionalism ideologies. In this context, Jefferson admitted that rebellion was a rational response to slavery. He famously wrote, "I tremble for my country when I reflect that God is just, that his justice cannot sleep forever, that considering numbers, nature, and natural means only, a revolution of the wheel of fortune, an exchange of situation, is among possible events, that it may become probable by supernatural interference." These words foreshadowed America's Civil War and the devastating consequences of the founding generation's decision to enslave 500,000 Black colonials, deny them fundamental due process of law, and propagate the false narrative that America was preordained to be a white nation where Black individuals were chattel property. And yet here in America, that lie has proven to be durable, transforming into the toxic ideology of white supremacy and the gospel of American exceptionalism, twisting our ideals into chains. Jefferson knew the truth. He knew that the narrative of slavery was incompatible with the principles of liberty, equality, and justice. He warned that this system, born of greed and perpetuated by willful blindness, was a moral calamity and a national sin. Jefferson's words are not just a relic of the past, they are a challenge to the present. We who inherit this nation must confront the contradictions that were woven into its fabric at its birth. We must wrestle with the truth that the promises of the Declaration were not extended to all, and we must fight to ensure that those promises are fulfilled today. The year is 2143. In the heart of the United States, now known as the Commonwealth of Free States, the descendants of the 500,000 wrongfully enslaved Afro-Englishmen thrive in a society that has finally realized the ideals of liberty, equality, and justice for all. This new government, deeply rooted in the foundational principles of the Declaration of Independence, actively ensures that all men are created equal is more than an aspiration, but a lived reality. By embracing the Declaration's call for a government that derives its just powers from the consent of the governed, the Commonwealth has established a truly representative democracy, one that safeguards individual rights, promotes equitable access to opportunity, and upholds the moral imperative of justice for past and present wrongs. New Columbia, the nation's capital, stands as a beacon of technological innovation and social harmony, built on the principles of historical recovery, restorative justice, and equitable governance. At its core is the Grand Archive, a sprawling digital repository preserving and integrating the rediscovered histories of those who were once denied their rightful place in the nation's narrative. The archive's holographic chambers allow citizens to experience the lives and struggles of their ancestors, fostering a profound connection to history and ensuring that the truth is never forgotten. In this future, racial hierarchies have been dismantled, and the Commonwealth operates under a governance model inspired by Afrofuturist principles, where technology, ethics, and democracy converge to serve all citizens. The legal system, rebuilt on principles of restorative justice, acknowledges the historical injustices of slavery, Jim Crow, and systemic racism, actively working to repair the damage done over centuries. Reparative policies, including universal access to education, health care, and wealth redistribution programs, have ensured that generational disparities have been eradicated. At the forefront of this new society is Dr. Amari Toussaint, a historian and technologist leading the Memory Initiative, an advanced AI-driven program that allows individuals to interact with historical figures using quantum memory reconstruction. Through this technology, citizens engage in dialogues with the voices of the past, including those of enslaved ancestors, abolitionists, and visionaries like Thomas Jefferson. His once ignored fears of divine justice, articulated in his 1785 work notes on the state of Virginia, have become central to national education. Jefferson's reflections on slavery as a corrupting force, on the enslaved, the enslaver, and the entire nation are now a cornerstone of moral and historical studies. His warnings of divine justice and social upheaval are displayed in interactive exhibits, ensuring future generations grasp the gravity of America's historical contradictions. The cities of the Commonwealth are marvels of sustainable technology, incorporating Afrocentric architectural designs, vertical farms, and zero-emission energy grids powered by solar and kinetic energy. Space travel, once a distant dream, has become accessible to all, with Wakanda Station, a nod to the legendary Afrofuturist vision, orbiting Earth as a center for interstellar diplomacy and scientific advancement. Culture flourishes in ways never before imagined. The arts, infused with Afrofuturist expression, weave together music, visual storytelling, and digital immersive experiences that celebrate Black identity across time and space. Education is an immersive experience where students use neural link interfaces to learn history through sensory experiences, ensuring that past injustices are not only remembered, but emotionally understood. Though the Commonwealth has achieved extraordinary progress, the people remain vigilant. The lessons of the past, of how oppression once thrived under the guise of democracy, are woven into the fabric of society, serving as a cautionary tale. The descendants of those wrongfully enslaved have reclaimed their place in history, ensuring that no nation ever again sacrifices justice for the sake of power. As the stars shine over New Columbia, a new generation stands ready to guide humanity toward even greater heights, forever honoring the resilience of their ancestors and the vision of a truly just world. Please share and visit our website at Wells Center on American Exceptionalism and look for future videos.